Alrighty, good afternoon, everybody. My name is Steve Jewett. I'm an Orange County judge in the Ninth Judicial Circuit of Florida, which is Orlando.
Good afternoon. My name is Doreen Hartwell, and I am an attorney in Las Vegas.
And good afternoon. I'm Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals.
It's nice to meet you all. My name is Conrad Drews, and I plan on attending University of Nevada, Reno for political science. And outside of We the People, I participate in Robotics Club and the tennis team.
Good afternoon, judges. My name is Laura Flynn. I plan to study psychology in the fall at University of Nevada, Reno. And in addition to We the People, I'm the captain of my soccer and softball team and an officer for the National Honor Society.
Hi, my name is Nicholas Pietzke. In the fall, I plan to study economics. And in addition to We the People, I'm in National Honor Society and the captain of the cross country and track and field team. We are here with our coaches and teachers Milton Himes, Sean McClelland, Ryan Spisman, and Ashley Nickel.
Alrighty, and we are here for Unit 5. Today we'll be discussing question 1. Question 1 reads as follows. A result of the decision in Wisconsin versus Yoder is that, quote, any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying that it's against their religious beliefs, end quote. Do you agree or disagree with this result of the decision, and why or why not? A couple extra questions are, what words, if any, are found in the United States Constitution or in state constitutions that protects the right to an education? And finally, how have courts balanced religious beliefs with other rights? You have 4 minutes.
In Yoder, Chief Justice Berger wrote, the unchallenged testimony of acknowledged experts in education and religious history, and almost 300 years of consistent practice support the claim that compulsory formal education after the 8th grade would gravely endanger, if not destroy, the respondents' religious beliefs.
We agree with the decision in Wisconsin v. Yoder because it provides a religious exemption to compulsory education, which may have otherwise harmed the long-standing Amish faith. However, this case is an exception to the rule, and in future conflicts between faith and education, the right to learn must be adequately protected.
Over time, the Yoder decision has had limited impact on education and other rights because free exercise protections were eroded in subsequent cases. For example, in Employment Division v. Smith, the court limited the scope of the compelling state interest standard for free exercise claims established in Sherbert v. Verner.
In 1993, the Religious Freedom Restoration Act attempted to restore strict scrutiny standard. In City of Bernie v. Flores, RFRA was ruled partially unconstitutional. Collectively, these Supreme Court decisions and RFRA muddled the Yoder precedent and undermined free exercise protection.
Although there are no provisions in the Constitution that guarantee a right to learn, we believe there should be an explicit right to education so that it is uniformly treated as a fundamental right. The Universal Declaration of Human Rights states in Article 26 that, quote, everyone has a right to education. And additionally, 135 countries guarantee education as a constitutional right.
Implicitly, the 10th Amendment allows states to govern over education, and all 50 state constitutions do guarantee some form of basic education. In order to effectively protect education, though, the national government should adopt the wording of Wyoming's state constitution, which ensures a complete and uniform system of public instruction.
To balance religious beliefs with other rights, the Supreme Court usually reviews the specific circumstances of a case and decides them on an individual basis, as it did with Yoder. However, the court has also attempted to balance rights by establishing various tests. For example, the court employed the Lemon test devised in Lemon v. Kurtzman and the endorsement test developed in Lynch v. Donnelly. These tests have led some to describe the Supreme Court's interpretation of religious clauses as a, quote, hot mess, such as the appeals court for the 11th Circuit did in Kondratiev v. City of Pensacola.
The court has recently had to balance religion with health concerns regarding the COVID-19 pandemic. In Roman Catholic Diocese v. Cuomo, which held that the state regulations on capacity limits must be content neutral and not discriminate against religious service.
Another contentious area concerns religion and expression in schools. For example, in Engel v. Vitale, The Supreme Court ruled that compulsory prayer in school violated the Establishment Clause, and they reaffirmed this idea in Abington v. Shemp by ruling against school-led biblical readings. Though unpopular at the time, these cases helped clarify that prayer in school went too far and fueled the debate over how separate church should be from state.
A recent study by Professors Lee Epstein and Eric Posner notes that prior to the Roberts Court, religious organizations received a favorable outcome about 50% of the time. But now, religious groups win over 81% of their cases. With this research in mind, the court must work to continually balance religious beliefs with other rights or risk harming both.
Fellow Nevadan Mark Twain summarized our government's inability to reasonably balance secular and religious interests when he stated, "In matters concerning religion and politics, a man's reasoning powers are not above the monkey's." Thank you.
Is it me? All right, I'll go. I'm going to skip it. I'm very interested in the things that you said. You guys laid out a very compelling case in your opening statement about the importance of education and how government has a big role in education, but yet you agreed with the Yoder decision. And so how do you, how are you going to be able to, how do you square that?
We agree with Justice Breyer's partial dissent, which still agrees with the decision of the court, but nuances it by saying that it is only made this way because of the culture surrounding the Amish and how they have a strong cultural identity and are learning much of what they would at school at their or because of their religion and community anyways.
I would have to agree with the majority opinion in Wisconsin v. Yoder because the court outlined very specific circumstances of the Amish faith that allowed this exemption from school. They were not burdens on society. The Amish people are law-abiding citizens, and they also have an adequate school system in their own community. And for these reasons, they were able to have an exemption from public schools.
While we agree with the decision, I think now that this decision wouldn't be such a great decision. We can see in a recent survey done by Annenberg that 23% of Americans could not name even a single branch of the US government, and therefore education must be given a higher priority.
Okay.
What are the advantages and disadvantages of having an established religion?
Could you repeat that question?
So what are the advantages and disadvantages of having an established religion? And from the context of, be it such as the Church of England, or an established religion in the formal sense versus, you know, as in Catholicism or Judaism or something of that nature?
One disadvantage would be the exclusion of other people who are not part of this religion. People would not feel that they're part of the government and that they're sort of ostracized from society for merely not believing in the religion.
One advantage would there might be more consistency when it comes to courts ruling on the establishment of a religion because there's only one national religion. However, I believe that this would actually create more conflict and divide in our nation because the Establishment Clause specifically balances out with the Free Exercise Clause because it allows everyone to freely exercise their beliefs without running into anyone else's beliefs.
One other benefit would be a greater cultural identity and civic identity. More of the country would be motivated to have the same beliefs, which is a belief of classical, or which would assist in the classical Republican belief that a country should be a uniform and small group of or demographic.
You mentioned in your prepared remarks that the court has been struggling recently in evaluating COVID-related restrictions as they apply to the exercise of religious rights. You mentioned the Cuomo case. The justices have different viewpoints on how to evaluate whether a law is neutral to religion. What are your takes on how you determine neutrality?
Sorry, you can go.
I disagree with the most recent decision in Tandon v. Newsom that that all COVID mandates about having groups of people to your home shouldn't count because of religious exercise. I agree with the precedent set in Employment Division v. Smith, which set that all laws should be neutrally applied to all people, no matter what religion they have, and you shouldn't be granted any exception because of your religion, other than legislative exceptions.
Did you have something else you wanted to say?
I would completely agree with my colleague that content neutrality means that it applies to all circumstances despite the content, which also applies to religion. We should not discriminate on religious businesses or services just because they are religious.
Is it back to me again? Oh, okay. Well, you know, in the Yoder case, I think you guys said it's very limited to those facts. What about a situation, and this is just in general, let's say one of those kids, the Amish kids, wanted to go to school. Where do the rights of the kid to have an education come in, and how do they balance with the parents' rights of religious belief?
The partial dissent in Wisconsin v. Yoder actually considered this, and they said that the children should have to consent to being pulled out of school. And we can see that parents don't have total authority over their parents in Pierce v. Massachusetts, or over their children in Pierce v. Massachusetts, when they ruled that if you're putting your child in harm, physical harm, you don't have the right to do that under parental rights.
However, Myers v. Nebraska did rule that parents have the right to raise their children as they see fit. And the majority in Yoder decided that it would be an infringement on the parents' rights to not allow their kids to be taken out of school. But I definitely agree with my colleague that the students should definitely have a voice in whether they want to attend or not attend school.
Sort of a follow-up to that question, to the extent that it's a negative right versus a positive right being enforced, do you think the analysis would be any different with regards to the protection of children versus parents' rights?
I think it would be different if it was a constitutional right, which I actually support. I think if education was a constitutional right, a positive right in the Constitution, it may have ruled differently because strict scrutiny would be applied to the education.
If it was a positive right, I think that there would have been a little bit more of an intervention done by the state, because a positive rights requires some sort of action by the government to guarantee a right. So I think there would have been probably the government may have stepped in and forced the children to go to school.
You made a strong case for a national right to education in your opening remarks. My question is, what, if any, would be the downsides to recognizing such a right?
One downside would be that the federal government would have oversight over all the states, which would mean that they would have to provide for equal funding, which could be a good aspect of it, but they would have to cut down either the infrastructure budget or the military budget to pay for this. And also there are very different circumstances in each state. For example, California has a population of over 39 million, while Wyoming only has slightly over 700,000. So there needs to be different regulations based from state to state.
Time.
All righty, good job. I'll go ahead and jump in. Like I sort of buried the lead here. I'd let you guys know. I mean, I thought that you were, and Aaron just said it, you made a compelling case in your opening remarks for a requirement of, you know, of education for a national right to education. I mean, it's you have put all of the history into it, and I think that it's there. Like I said, I was shocked that you're for that, except you were willing to allow that very extremely important thing to be ripped away from some poor lad or lass who would love to go to school, but their parents have decided that no, we don't want you to be a doctor, a lawyer, or an engineer. We want you to go and pick turnips for the rest of your life. Which I understand that's their religion and that's what they want them to do. But to me, that just seems without the child having any ability to lose that right. And I learned today that about 20%, I think, of the people, or maybe it was 10% of the people of these Amish people leave, which is something that to me is then, okay, if it's this detriment to the society, which you laid out perfectly, let's say it's 2 million people, that's still, that's a couple 100,000 people who are not going to be prepared. So that's a problem. I thought that opening statement was fantastic. You were able to respond to questions that were put to you that dealt with cases, and then you brought out your own cases. I thought that the argument about the case for the national right, what it always comes down to is money. And you're absolutely right. I mean, if it became that's going to be, that's a difficulty. And then also one thing you could throw in there is that every state is demographically different and all that, and have different strategies in education. But really good job. Excellent.
Yeah, I thought you guys did an excellent job from your prepared remarks, both the content and the presentation. Each of you delivered your portions with just passion. It wasn't monotone, and that was just really well done. And then with regards to the content, you covered everything. You stated your position, and then you supported it with historical facts, with obviously references to the Constitution, Supreme Court precedents. And I like that you, and I loved how you ended on the Mark Twain quote. I thought that was really neat. Your responses to the questions, I thought, were excellent. You really, and to the extent that the first question that I asked and you needed some clarification on it, yeah, it's like way to ask for it. If you don't think it's clear, absolutely ask the judges to rephrase. But then I thought you guys pretty much nailed it when you responded to it. I thought your responses to most of the questions, all of you provided just great responses. And what was really neat was, even though you are clear with regards to your position, you were able to see other perspectives, and you actually gave evidence in support of other perspectives, even though your where you ended up was different. And I thought that was really good too. It just demonstrated that just a wealth of understanding with regards to the content. Just well done. Good job.
Thank you.
I agree. I too loved your Mark Twain reference, and it demonstrated a lot of state pride too, which was it's fun to watch. It's like, this is a really cool experience to see people from all over the country and see the variations. Your knowledge was very solid. Especially you demonstrated that you had knowledge of the fact that these are complicated issues, and not even the members of the Supreme Court are agreeing on it either contemporaneously or across time. These are very, very hard and very, very important issues to people, and aren't something that you would necessarily expect everybody to agree on. And I think one thing I really appreciated about your presentation, you seem to very much recognize the human element of these issues. It's not laws, not just the sort of cold thing where when you were describing your perspective on Yoder, you talked about how, yes, the exception for religion there was important because of the documented destruction on the Amish community, but then you pulled back and recognized also that having a narrow rule might be important, because having too many exceptions, could really be destructive to our democracy. And there's no easy answers to this, but I thought your willingness to recognize the gray areas and explore those in a very you had a great team dynamic, was just wonderful to watch. So nice job. I've enjoyed this time with you.
Yeah, thanks a lot. There's a lot going on in this country now, and it's very kind of, what's the future going to be? I'm an old guy. I'm going to be gone in a little bit, but it's good to see youngsters such as yourself it makes me think that the future is going to be okay. We got people like yourself who really are caring and quite the underachievers after you introduced yourself and all the things that you're involved in. You know, I mean, when do you have time to do anything? You're so involved, and you make me proud. So good luck to you guys. Also, I liked your pin too. I got one. I have that same pin. So there you go. But yeah, good luck to you guys. Hopefully you're going to do very well.
Thank you all
everyone,
so
for your
much.
Yeah, thank you all so much.
Good luck.